Good morning, all of you. Today we are going to deal with the concept of public interest litigation in India. Let us see what is meant by public interest litigation and what is the format for filing a public interest litigation in India. So, a public interest litigation is introduced in a high court or the Supreme Court, not by the aggrieved party, but by a private party or by the court itself. The powerful weapon for enforcing the legal obligation of the executive and the legislature. And the purpose of a public interest litigation is to ensure justice to all and promoting the welfare of the people, as envisaged in the preamble of our Indian Constitution. And this public interest litigation is to safeguard the group interests and not the individual interests for which fundamental rights have been provided to us. And the concept of PIL stems from the power of the judicial review. Now let us see what is meant by judicial review. This judicial review is a doctrine under which the executive and legislative actions are reviewed by the judiciary. All of us must be knowing that we are following the principle of separation of powers of the three wings of the government, namely the executive, the legislative, and the judiciary. The judiciary is vested with the power of the review over actions of the other two wings. And the Indian Constitution adopted the judicial review on the lines of the American Constitution. And judicial review is used to challenge the decisions of the public authorities in India by judicial review to review the lawfulness of a decision or action or a failure to act by a public body. Let's see what is meant by the principle of locus standi now. Suo motu cases and the public interest litigation with the discontinuation of the principle of locus standi has allowed the judiciary to intervene in many public issues, even when there is no complaint from the aggrieved party. And the principle implies that only the person or party whose rights have been infringed can file the petitions. And then there are certain landmark judgments of the Supreme Court, like banning of the instant triple talaq, opening up the doors of the Shabarimala and the Haji Ali shrines to women, legalizing consensual homosexual relations, and legalizing passive euthanasia, etc. So these are all judgments which are pointing towards the welfare of the people and ensuring justice to all. Now let us see the procedure to file a public interest litigation. Any Indian citizen or an organization can move the court for a public interest or cause by filing a petition. The only thing you have to ensure is that there is a public interest or some cause involved. And it is filed in Supreme Court under Article 32. You must be knowing that Article 32 itself is a fundamental right. It's actually the constitutional right to remedies. And in the High Courts under Article 226. Now let us see the steps to file a public interest litigation. In the case of a public interest litigation, the court can treat even a letter as a writ petition and take some action on it. The court has to be satisfied that the writ petition complies with the following matters. First of all, the letter is addressed by the aggrieved person or a public spirited individual or any social action group for the enforcement of legal or constitutional rights to any person upon poverty or disability are not able to approach the court for a redress. The court can also take action on the basis of newspaper reports if it is satisfied with the case. Now, some history also we can add to this particular session. Kapila Hingorani filed a petition and secured the release of almost 40,000 under trials from Patna's jails in the famous Husainara Khatun's case. And that was in the year 1979. And this case was filed in the Supreme Court before a bench led by Justice P. N. Bhagavati. And Hingorani is called the mother of the PILs as a result of this successful case. And in this case, the court permitted Hingorani to pursue a case in which she had no personal locus standi, making PILs a permanent fixture in the Indian jurisprudence. Public interest litigation do not insist on the observance of procedural technicalities. And it even treated ordinary letters from public-minded individuals as writ petitions. That's the beauty of it. And Justice Bhagavati and Justice V.R. Krishna Iyer were among the first judges in the country to admit the PILs. And what is the importance of public interest litigation? By mentioning all these factors which are related to this public interest litigation, you might have understood the importance. Even then, let's see what are they. The original purpose of PILs has been to make justice accessible to the poor and the marginalized. We can see that from allowing even letters to be considered as writ petitions in the case of this public interest litigation. And it's an important tool to make human rights reach those who have been denied the rights. Even though the word human rights is not mentioned in the Indian Constitution, all our fundamental rights are human rights itself. And it democratizes the access of justice to all. The preamble of the Indian Constitution envisages justice for all, socio-economic and political justice. And this principle of public interest litigation democratized the access of justice to all the people of India. And any citizen or agency who is capable can file petitions on behalf of those who cannot or do not have the means to do so. And it helps in judicially monitoring the state institutions like prisons, asylums, protective homes, etc. So these are the places where lots of human rights violations are happening. So a judicial monitoring is very much needed to ensure democracy. And it's an important tool in judicial review too. But there are certain matters which are not entertained as public interest litigation. Our discussion will not be complete without mentioning these matters also. The matters returned to the petitioners. Since it is not entertained as PIL are landlord-tenant matters, service matter and those pertaining to pension and gratuity, admission to medical and other educational institutions, then petitions for early hearing of cases pending in high courts and subordinate courts, etc. So obviously you can find that these are all kind of cases which cannot be taken under the public interest litigation because of the very nature of these cases. And this particular public interest litigation concept is not free from criticism. It is having not much criticisms, like nowadays the public interest litigation have become a tool for publicity. And people file frivolous petitions which result in the wastage of time of the courts. Courts are already burdened with lot much cases. So people have used them with a political agenda as well. Maybe you are having political rivals and maybe you will try this as a weapon to use against them as a part of the political agenda. And these kind of frivolous petitions are unnecessarily burdening the judiciary. And even if the petition is eventually dismissed, the court spends some time and effort on them before dismissing them. Because at present, only the judges have the power to dismiss a petition. When you go to file the petitions in the Supreme Court or High Court, the registry of the Supreme Court or the High Court only ensures that the technical requirements of filing a petition are fulfilled. So all the petitions are admitted to the court, irrespective of the merits of the case. And when frivolous petitions are filed, the precious time of the court is wasted even on dismissing these petitions. And when you refer the latest public interest litigation cases, PIL has moved to quash the PMKS fund. It has been filed in the Supreme Court seeking directions to the government of India to make arrangements in order to rescue and bring the Indian migrants stranded in Gulf countries. And a petition has been filed before the Supreme Court seeking directions to states the municipal authorities and the local self-government authorities to ensure the protection of rights of the sanitation workers who are also essential service providers amidst the nationwide lockdown in the wake of the COVID-19 breakup. And now let us see the format of this public interest litigation. So it's just like a writ petition that we are filing a public interest litigation in a court of law. First of all, we have to mention the name of the court to which we are filing this particular petition in the Honorable High Court of Judicature at maybe Kerala, maybe Madras, whatever. An original writ jurisdiction you have to mention. Then public interest litigation number dash of 2021. Maybe this year we are filing a public interest litigation number. We can put the writing like this. And maybe in the matter of Article 19 or any other article of the Part 3 of the Indian Constitution. Part 3 is actually the fundamental rights. And Article 226, since this case is filed at High Court, we have to mention Article 226. And in the case of filing in Supreme Court, Article 32, you have to mention of the Constitution of India by the petitioner and the respondent. If more than one respondents are there, you can add their names also. Then comes to the Honorable Chief Justice and other Honorable Pune Judges of the High Court of Judicature at Kerala or whichever court the petition is being filed in. And humble petition of the petitioner above named the most respectfully shower. Then you have to narrate the facts of the case. Then you have to mention the relief sought from the court. And then, and for this act of kindness and justice, the petitioner is, as in duty bound, shall ever pray. Place, date, then it's to be signed by the petitioner, advocate for the petitioner. And when you are filing a public interest litigation, it is to be accompanied by an affidavit signed by the petitioner. So an affidavit is filed so that you are assuring, you are solemnly agreeing that whatever is mentioned in this particular writ petition is true and correct to the best of your knowledge, belief, and faith. So these are all the things which are related to this public interest litigation. And with this, I am winding up my session. Thank you, everybody.